Hi guys. Today I want to talk about how you can apply for a visa to come to live in the UK if you are parents living overseas who have British or settled children living in the UK. In this video, we will consider the requirements that the parents applying for a visa in this category must meet in order to make a successful application. So I'll start with going through the main issues for the applicants. The key requirements are that they must meet the relationship requirements with the child. They must not be in a relationship with the child's other parents or carer, and they must provide evidence that they are taking and intend to continue to take an active role in the child's upbringing. The parents must also be outside the UK. They must be over 18 years of age, and they must be able to adequately maintain, accommodate themselves, and any dependents on arrival. They also must be able to speak English to an acceptable level, level A1 in this case. The child must be living in the UK. The child must be under the age of 18. Anyone under the age of 18 in the UK is considered a child, and they must be a British national or have a settled status in the form of indefinite leave to remain or permanent residence, whichever the case is. The most tricky issue in this application is usually the relationship requirements. By relationship requirements, we mean the connection between the applicant's parents and the child, but also the relationship between the parents applying for the visa and the child's other parents if they're still involved in the child's care. So the relationship between the applicant's parent and the child. The parent can either provide evidence that they have sole parental responsibility for their child, or they can provide evidence that the British parent or carer with whom the child currently lives with in the UK is not their partner, and that they have direct access to the child. So there are two issues in that requirement. The first means that the parents must be separated, they must be divorced, or they're not together, the relationship is not sustainable. And secondly, they must show that they have direct access to the child. I'll go through the exact requirement as set out in the immigration rules. The applicant must have sole responsibility for the child, or the parent or carer with whom the child normally lives with must be a British citizen or someone with indefinite leave to remain. They must not be the partner of the applicant, which means they mustn't be the partner of the person applying from overseas. The applicant must not be eligible to apply for entry clearance as a partner, which means the applicants and the other parents must not be in any form of relationship that is sustainable. So the applicants must provide evidence that they have either sole parental responsibility for the child, or they have direct access to the child as agreed with the parents or carer with whom the child normally lives, or as ordered by a court in the UK. So what that means is the parents could have separated, but they could have some form of agreement, for them to play a role in the life of the child. If the parent does not agree to this agreement, the other parent can go to the UK court to obtain access under Section 8 of the Children Act 1989. It's usually called contact, but in the family law sector, they prefer to call it access. But I'll go in more details as I move on, and I'll explain how you can obtain access. But at the moment, I'll just continue with the key requirements. So whichever route is being relied upon in the application, either sole responsibility or direct access, evidence must also be presented which shows the applicant will take an active role in the child's upbringing. So, in the course of making the application, you must show that you intend to play an active role in their lives. So, this could be in the form of you making a statement to show that you would play the role of a mother, you would nurture them, you would care for them, you would take care of the medical needs, you will provide food, you will provide housing. It's just you setting out your aspiration for the children, what you intend to do, your role. They want you to put it in writing or in any form in which you can explain yourself. So who qualifies to be a parent? The stepfather of a child whose father is dead. And the reference to stepfather includes the relationship arising through civil partnership. A parent can also be the stepmother of a child whose mother is dead. And the reference to stepmother includes a relationship arising through civil partnership. The father, as well as the mother of an illegitimate child, where he is proved to be the father. Here, what the means is if you're not able to provide the birth certificate of the child, you might be able to prove you're the child's parents by providing DNA samples or the result of your DNA tests that can show that you're the father. And for you to be able to satisfy the home office that the DNA test is genuine, you need to carry out the test from a hospital which is reputable and recognized by the home office, and it must be verifiable. So an adoptive parent as well can also be a parent so far as the adoptive rules of the country is recognized by UK laws. So really, what does sole parental responsibility means? The test is not whether anyone else has day-to-day responsibility, but whether the parent has continued control and direction of the child's upbringing. So what this means is that you can be overseas and be making key decisions in the child's life. For example, if you're a Christian, you might want this child to be baptized in the church, or you might want this child to go to a Christian school, or if you're a Muslim, you might want this child to learn Arabic, you might want to bring this child up in an Islamic way. So you need to show evidence of the steps which you've been taking. It could be by way of telephone conversations, it could be by way of what you've agreed with other parents, or it could be by way of what you say to the courts that you want to, of why you want to have access to your children. So those are just some examples. It's quite broad. But the courts are set out a list of consideration to be taken into account by decision makers looking at these questions. They should be read carefully by anyone making an application where this might be an issue. So the first one is who has responsibility for a child's upbringing, and whether that responsibility is sole is a factual matter to be decided upon the evidence. The term responsibility in the immigration rules should not be understood as a theoretical or legal obligation, but rather as a practical one, which in each case looks to who in fact is exercising responsibility for the child. That responsibility may have been for a short duration, in that the present arrangement may have been quite recently. So it may be that they the parents are divorced, and the parents in the UK has not been allowing the parent overseas to have contact with the child. So here, if you in the course of making the application for child arrangement order under Section 8 of the Family Law Acts, it is very important to set out what you desire. And one of the ways which you will set this out will be through your assessment by Kafkas. Because before the court makes these orders, before they make the child arrangement orders, Kafkas will interview you. They will interview the child to ascertain their wishes and feelings. So Kafkas would want to find out exactly what your intentions are, and it is Kafkas are the social workers that advises the courts. So Kafkas would make recommendation to the courts on what they believe is in the best interest of the child following the assessment. So it is on the basis of that advice that the court will make orders that will enable you to exercise your wishes and have contact with the child. And as I said earlier, this is applicable where you and the parents in the UK could not reach an agreement, or where there is wait, there's been a divorce and there's animosity in the relationship, and you cannot have a sensible conversation with the other parent. So you need to go to the court to enforce your right to play a role in the life of your child or your children. So key evidence of sole responsibility. A really key issue will be the evidence of contact between the applicant parent and the carer on important decisions to be taken about the child and his or her upbringing. In situation where only one parent is in the picture, if that parent can show that he or she has control over a major decision that affects a child's life, even from afar, then this will be strong evidence to suggest that they meet that sole responsibility test. An alternative to the sole responsibility test would be that you intend to come to the UK to play an active role in the lives of the children. I've explained that earlier. You can demonstrate, or you can say to Home Office in a written statement that you intend to come and play the role of a mother, and you would give examples of what mothers do day to day, caring for the children. You clothe them, you wash them if they're children, if they're kids. You provide a safe space for them. You take them to GP. You cook their meals. You nurture them. A whole lot of examples that you can give. So, what does direct access mean? This is another key consideration. In cases where sole responsibility cannot be shown, the parents must demonstrate that they have direct access in person to the child, as agreed with the parents of the carer. So, here, if the relationship between the parents in the UK and the parents abroad is tolerable, they could have a written agreement and set out in writing what the role of the parents coming into the UK would be. But if they cannot come up with an agreement, then the parent overseas can obtain a court order that would enable them to see their children. Sometimes it can be complex to obtain these orders, especially where the parents in the UK frustrates or attempts to frustrate the family proceedings, because sometimes, in my experience, parents have been invited to attend courts and sometimes they did not attend courts, and you need to take drastic steps before, or enforcement action before they can be brought to the courts, and sometimes these proceedings are quite expensive. So, but of course, it's very effective. It's a criminal offense to breach UK court orders, and so one of the sanctions can be imprisonment. It's contempt of courts to disobey court orders. So, key evidence of direct access. It is important to note that the courts don't have to be involved for an applicant to meet this requirement. As I've explained earlier, it is possible for the parents to make contact arrangement between themselves. But whatever arrangement is in place, it will be useful from the point of view of the visa application if it's been documented in some ways. So evidence might be email, it might be WhatsApp messages, but you need to be very careful to show that a relationship does not subsist. And one of the ways you can show that is if the parents have, if the so you could present as evidence that the relationship are permanently broken down, because the Home Office, one of the things they'll be looking at is to ensure that this route is not being circumvented to enter the UK rather than applying through the partner's routes. So also you would also demonstrate how you intend to have contact with the children. It may be that the court in the order has defined the time you would spend with the children. It may be that the court would have said you can speak to them once or twice every week over telephone, or you can send them emails or have a Skype or Zoom conversation with them. And the court can also make an order that, this would continue until you enter the UK to have a physical contact with them. So that means the court could actually say, okay, start with telephone calls once or twice every week or every fortnight, then until you arrive in the UK. So once you arrive in the UK, you can meet them once in a week for 2 hours or 4 hours. If you come to the UK, or if at any point in time you're not able, the orders are not working, you can go back to the court to vary the order as you see fit. So essentially, the applicant parent cannot be in a relationship with the parent or carer who looks after the child. So that's what I've just explained there. So what are their other requirements? The applicants must show that they will be able to adequately maintain and accommodate themselves. So if you're applying, if you've got relatives in the UK, they can show that they would accommodate you and maintain you whilst you in the UK. I mean, initially, because sometimes it's just not feasible for you to have the accommodation and the resources for you to maintain yourself. And there isn't any income requirement, so it's just will be reasonable if you can find someone, a relative, a close relative, who is employed, who has a house, and they've got a space to accommodate you. It would also assist the application as well if you can provide a property survey to show that there will not be overcrowding in the accommodation. So I think I've said this earlier that you would need an English language requirement unless you're exempt, and this is level A1 English. And in addition to that, you'll make sure you meet the suitability requirements. I think that's it for now. I hope this helps. If you require further information, please feel free to type a question in the box below, or email me directly. I'll be more than happy to respond as soon as I can. Thank you.